Hey everyone, we've all heard the phrase contempt of court, right? It gets tossed around a lot, especially in the news. But what does it really mean? What does it take to actually scandalize a court? And could you get in trouble for it? Well, today we're going to break it all down. We're diving into the power behind this law and that really tricky line between free speech and a straight-up criminal offense.
So, to get us started, let's jump right in with a question. Have a look at this. Which one of these actions counts as criminal contempt under the Contempt of Courts Act of 1971? Is it A, just disobeying a court order to pay a fine? B, publishing an article that, scandalizes or lowers the authority of a court? C, maybe failing to show up as a witness when you're summoned? Or D, just making a fair and accurate report of what happened in court? What do you think? Okay, lock in your guess. Go ahead and drop what you think it is, A, B, C, or D, right down in the comments below. Don't worry, we'll circle back to the right answer a little later, but trust me, by the time we're done here, you'll know exactly what the right answer is and why.
All right, so where does this whole idea of contempt of court even come from? Well, to figure that out, we have to go straight to the top, to the Constitution of India itself. See, this isn't just some regular law that was passed. Nope, this power is literally baked right into the country's foundational legal blueprint.
The Constitution lays the groundwork in a couple of really key places. First, you've got Article 19(2). This one's super interesting because it says, hey, you have freedom of speech, for sure, but it's not a free-for-all. It allows for reasonable restrictions, and one of those is specifically for contempt of court. Then you have Articles 129 and 215. These basically label the Supreme Court and the High Courts as courts of record. Now that's a fancy term, but what it really means is that they have an inherent power to punish for their own contempt. They don't need any other law to give them permission. The power is just built in.
But, the Constitution just gives the big picture power. It doesn't get into the nitty-gritty. For all the specific rules and definitions, we need to look at the Contempt of Courts Act from 1971. Think of this as the official rulebook. It's the playbook that spells out exactly what counts as contempt and how the courts are supposed to deal with it. So one of the first things you notice about this act is that it splits contempt into two distinct categories. It's not just one big bucket. You have civil contempt, and then you have criminal contempt. They sound similar, but they're very different. Let's break down what each one is. Okay, first up is civil contempt. The key words here are willful disobedience. It's pretty straightforward, actually. Let's say a court tells someone to do something specific, like pay a fine or hand over some documents. If that person just knowingly and deliberately refuses to do it, well, that's civil contempt. It's about directly disobeying a court's specific order or judgment. Now, criminal contempt, that's a whole other ballgame. It's way broader. We're not talking about just ignoring one specific order here. This is about any act that basically attacks the justice system itself. Things like publishing something that scandalizes the court, or trying to interfere with a case while it's happening, or doing anything that obstructs the administration of justice. The focus here isn't on one person's disobedience, it's about protecting the integrity and the public's trust in the entire judicial system.
So, to put it simply, one is about disobeying an order, the other is about undermining the whole system. Let's put them side by side to make that difference crystal clear.
This really lays it all out, doesn't it? Civil contempt on the left, that's about disobedience. You willfully disobey a specific order. The focus is just on upholding that one ruling. But then you look at criminal contempt on the right, that's about scandalizing and interfering. We're talking about lowering the court's authority or obstructing justice in a broader sense. The focus isn't just one order, it's about protecting the very integrity of the judicial system for everyone.
Okay, so now that we've got a handle on the difference between civil and criminal contempt, let's go back to that question from the very beginning. Are you ready to see the answer?
And the answer is B. Publishing an article that scandalizes or lowers the authority of a court. This is the textbook definition of criminal contempt. Why? Because it's not about disobeying one single order. It's an act that has the potential to damage the public's faith in the court as an institution. The other options, well, they're more about disobeying specific directions, which puts them squarely in the civil contempt category.
But this, of course, raises a huge question. If publishing something can be criminal contempt, then what about fair criticism? What about free speech? This is where things get really, really nuanced. Where is that line?
Well, you'll be glad to know the courts have thought about this a lot. In fact, way back in 1952, in a famous case, It was made clear that fair criticism of a decided case is not contempt. So you are absolutely allowed to pick apart a judgment, analyze it, and even strongly disagree with it. That's considered a vital part of a healthy democracy.
But, and this is a big but, there is a line. And a great example of someone crossing that line is the M.V. Jayarajan case from 2015. In that situation, a politician wasn't just criticizing a high court order. He was using abusive language in a public speech. The Supreme Court said, whoa, that's not fair criticism anymore. That's criminal contempt. Because the speech wasn't about the legal reasoning, it was an attempt to undermine the judiciary's authority and disrupt the administration of justice.
So it all comes down to this. Why does this law even exist? I mean, why have something that could potentially clash with free speech? What's the big idea here? The whole point of contempt law, really, isn't about protecting individual judges from criticism. It's not designed to shut down debate. The official goal is to protect the sanctity of the administration of justice. It's about making sure that the entire system can function properly, without intimidation or its authority being completely eroded, so that it can actually deliver justice for the public.
And that brings us right up to today, leaving us with a really tough question for our times. In this age of social media, where everyone has a platform and commentary is instant, that line between criticism and contempt can feel, well, pretty blurry. So how do we strike the right balance? How do we protect our right to speak out while also making sure our courts are respected enough to function effectively? It's a huge challenge, and definitely something to think about.